Okay, perfect, excellent. All right, sorry about that. Something's wrong with our audio from the telephone, so I switched over to the webcam. So to the audio. So all right, so now that we got everybody back and we can hear it again, let me go back a little bit and we can discuss. Just kind of start over here. As I was saying, the key items that we wanted to cover in this webinar is the things we want to talk about is who, first of all, should participate. We want to make sure that we talk about who should participate and what is the importance of first-hand testimony. For those of you who've been through an unemployment hearing with us or have been who have actually participated in a hearing, have been prepared or representation, you know we really talk a lot about the importance of first-hand testimony. The other thing that we're going to talk about is how to prepare for the hearing, what it goes involved and what you should focus your preparation on, what the things that you should look for when you're preparing for the hearing, and what are the things you should emphasize. As far as your testimony, we want to talk about what testimony is all going to be about. We want to talk about that fine line, that balance between too much and too little, and what you should be focusing on, what you should emphasize in your testimony. And then we're going to talk a little bit about the importance, what we think is the value importance of having somebody on the call with you who understands and is an expert in actual representation of the unemployment hearing. So the basic components of the unemployment hearing is, for those of you who are familiar with this, it's going to be kind of redundant, but this is something you could cover with your managers at a different time, is that it's very similar to a deposition. If you've ever been through a deposition or something like that, you would recognize that it's very close to that. The rules of evidence and testimony are enforced. You still have to provide relevant testimony. You still have to provide information that is relevant to the separation issue, but it's much less formal than a court of law. The situation is, hearsay evidence is acceptable, but it's only given the weight that it deserves by the referee. So that's one of the things that you'll want to talk, discuss in the when you're preparing, is who has the most first-hand information. In cases of a discharge, the employer presents their argument first, and in cases of resignations, the claimant presents their information first. Each party has the right to cross-examine the other party's witnesses. And we're going to talk a little bit about cross-examination, both being cross-examined and cross-examining the witness if you're on the call without representation. Basic foundation for evidence has to be established, and the evidence can be objected to it being included if you cannot establish foundation. Now, what is foundation? Foundation is basically proof that either A, the individual that is testifying about the document, the evidence, has knowledge about the document, and B, that the documents are relevant to the actual issue at hand, and that is the separation. Of course, for those of you who've been through an unemployment hearing, you know that it could be policies, witness statements, written warnings, etc. Okay. If you're still having issues with the sound, you might want to try to see if your speakers are unmuted, or if you have any, if you want to call back in here real quick, we'll give it a few minutes that you can maybe you see if you want to come back and see if you can dial in on the telephone. We'll give it just a minute. If you need the meeting ID number, it's 134-624-821, and I'll type it here in the box too. If you dial in on the telephone, you might be able to get to that. So to finish the basic components here real quick, the First-hand testimony is given the most weight. Okay, emphasis is placed on the last incident that led to the claimant's separation. For those of you who've been through an unemployment hearing before, you know that it almost always begins with the last incident, and it works backwards through the chronology of the unemployment, of the person's employment history. But the most emphasis, almost 75 to 80% of what is the determination, is placed on what was the final incident, the proverbial the straw that broke the camel's back, if you will, that led to them being separated from your employment. So most of your information, most of your testimony, and most of your preparation needs to be focused on the last incident. If you, all these other things that we're going to talk about as far as written warnings and whatnot, that's going to be included in what's going to be helping you create a foundation that leads up to that particular dismissal. Now, how to prepare for the hearing. Preparation is absolutely essential. This is a game first and foremost of credibility. They are looking for, the referee is going to be looking for a unemotional, dispassionate presentation of fact. They want to know who is going to have the most first-hand information pertaining to the actual separation and who is going to be the most credible. Okay, so when you're preparing for the unemployment hearing, you want to remove all the emotion that you possibly can. You want to base your entire argument solely and completely on factual information, as much fact as you can possibly gather. You want to also understand what it is that you're trying to prove. Okay, if you are trying to prove that the claimant's actions, for example, performance, that what is it you're trying to accomplish there? Remember, the goal is to prove misconduct. Misconduct is not the same as being an at-will employee. So what you're trying to do is you're trying to present factual evidence to show that the claimant deliberately and willfully violated a policy or procedure that is reasonably expected of the employer. So your goal when you is when you're trying to prepare for the hearing is to collect all the facts that you possibly can and put them in an order and a presentation that's going to show the referee that the actions were misconduct or negligent in their nature. Okay. So understand what it is you're trying to prove. If it's attendance, you're trying to prove that the claimant was absent without good cause, so on and so forth. Whatever it might be, you're trying to show that the claimant deliberately violated your policies and procedures. Have the correct documents. Almost, probably 50% of the time, no matter how hard we all try, we always have to end up sending some documents in with the hearing packet after we get the date and time of the hearing. Part of the preparation is making sure that you fill in the gaps and enhance your testimony with documentation. Remember, the claimant is going to usually deny just about everything. So one of the most effective tools that you can use to combat their amnesia is to provide the referee with policies, signed acknowledgments of policies, written warnings, witness statements, whatever it is that we can provide to the referee to help support the fact that the claimant violated your policies and they had knowledge of the policies and whatever else we can use those to accomplish. So make sure that we have a complete accounting of all the documentation that is relevant to the issue that they were separated for. Do you have the right witness? Okay. Again, this is an essential part of being successful at an unemployment hearing. It's having the right witness available. If you can't have the right witness, for example, it's a customer or a patient or whatever who witnessed the event, then you have to get to the next closest person. And that is an individual who took this complaint or who did the actual investigation into the incident. you want to try to get as close to the first-hand witness as you possibly can. Because remember, hearsay evidence is going to be admissible, but it is only going to be given the weight that is merited. So if you have a situation where you have the claimant who is always going to be providing first-hand testimony from their perspective versus second or third-hand testimony from the employer side, the referee is really bound by law to give more credence to that first-hand testimony. Now, they can take into account credibility of the witness, of the claimant. They can take into account different things like what the claimant has previously said during the adjudication process, etc. So that doesn't mean that it's not something that you can overcome, and it can be overcome, but that goes back to what we're talking about as far as understanding what it is you're trying to prove. And if you don't have a first-hand witness, you really have to be dead on with the documentation portion of it, okay? Because that is where you're going to overcome having second-hand testimony, is you have good, solid documentation at hand. We stress and strongly believe in making sure that you prepare a timeline for yourself. This is nothing that you're going to use, submit to the referee. This is going to be strictly for you and you only. This is your talking points. This is your roadmap, if you will, how you are going to testify. And more than any other thing, this helps with the flow of testimony. Remember, this is a credibility game. If you are capable, okay, of going through the documentation in your testimony without interruption, without shuffling through papers, whatever it might be, and you are snapping off information quickly to the referee's questions, it is going to make you sound more credible. You're going to win the credibility game. And what we strongly encourage you to do is just go through, starting from that last incident, and you just start bullet pointing out key elements of each incident. So last incident, you might talk about bullet point 1, 2, 3. Final written warning, bullet point 1, 2, 3, so on and so forth. If you work through the timeline and you work through the events that are relevant to each event, you're going to close the gaps in your testimony. It also helps you anticipate issues that the claimant may be bringing up during their testimony. This is something that sounds simple, but make sure all technical issues are covered. You know, calling in the correct, we do all that for you, generally speaking, but sometimes you have telephone issues. Sometimes you have, you need to meet certain deadlines in which to submit documentation or have your witnesses registered by. Make sure that you understand when it is that you have to have everything in by, because in certain states, if you don't meet certain requirements at certain stages through the hearing process, your documentation or your testimony may be excluded. Generally speaking, for clients who are our clients or current clients, we handle all that for you, and we rarely have an issue. But you want to make sure that you always have that covered, because you would hate to lose an unemployment hearing because you missed calling in a telephone number by the deadline or something to that degree. So make sure that you always have your technical issues covered as well. Now, when you're testifying at the hearing, before you even get into the hearing, review your timeline. Okay, the timeline is going to be, as I said, going to be your roadmap for helping you hit the key elements, the key points that you want to show to the referee that proves your case. Okay, you want to make sure that as you are doing that, you have all the documents in order of what you're going to testify to. Now, sometimes the referee is going to bounce around on you. Sometimes they're going to ask you questions out of order. That's fine, because again, that timeline, even if you're using a representative, when we represent a client, we still insist that you have a timeline, because we want to make sure that if the referee starts bouncing around on you and changes up the flow of testimony, you still have an easy checklist right there for you that you can check off stuff as we or the referee ask you. Okay? Sometimes we forget to ask you something. Again, it gives you an opportunity to raise issues at the end of your testimony that we may not have covered or forgotten to cover. All right, so it just is it's a fail-safe for us to make sure that when you're testifying, we try to keep everything in order and it's a good, easy flow of information coming to the referee. So after you have your timeline and you have your documents in order and you know how you're going to use them, obviously you're going to think about your testimony and you're going to try to anticipate issues with your documentation or your testimony. A lot of what we try to do in the unemployment hearing is we try to eliminate pitfalls or excuses, okay? When you get an unemployment hearing packet, you almost inevitably get a witness statement, the claimant statement from in the packets. This shows you, we go through these with a fine-tooth comb. We really look at these hard because that tells you or gives you a glimpse of where the claimant is going to be coming from during the course of the hearing. All right? This gives you an opportunity to anticipate and to plan for how you're going to react to the claimant's, the issues that the claimant is going to bring up. It allows you an opportunity to submit documentation ahead of time that is going to refute some of the key elements of their testimony. So you want to, when you're going through your preparation, you want to think about how you're going to testify. You're going to want to anticipate these problems, especially in cases of discharges where we get to go first. Remember, the employer has to present the case in a discharge first. If you anticipate what the claimant is going to say, you can go and control that message ahead of time. So if the claimant says, for example, in their statements, I was never given the policy handbook, I was never told there was a policy, one of the first things we should send is acknowledgement of the policy and the policy itself. If there's written warnings that will go through and cover the policy, we send those in because, again, you're eliminating an excuse that the claimant is going to try to present that justifies their actions. You're controlling the message. You want to try to control the message as much as possible. When you're asked a question, you want to provide a clear and concise answer, okay? Again, this goes back to the preparation part. Even the best witnesses stumble sometimes, okay? It's inevitable that you're going to have some pitfalls throughout the course of the hearing. If you are asked a question and you don't know the answer to the question, you simply say, I don't know. I don't have that information. The last thing you ever want to do is try to tell the referee a half-baked story when it's clear that you do not know the answer to the question. They would prefer that you be honest with them and tell them you don't know. Okay? Again, remember, credibility is everything. One of the biggest mistakes claimants make during the course of an unemployment hearing is some of them deny everything. Okay? That's a huge mistake. It damages their credibility. The referee understands you're not going to have answers to everything. So provide answers to when you can, and provide them clear and concise. But avoid raising issues outside of the questions, okay? One of the biggest mistakes employers make, all right, is that the witness won't stop talking, all right? Answer the question. Make sure that the question emphasizes the point that you want to make as best you can, and that enhances your position as best you can. But stop talking. Do not say yes, but, or yes, and. Or, remember, one of the key elements of testifying is this. If you're not asked a question and you don't offer information, it's not lying, okay? You're not lying if you don't offer information that you're not asked, okay? So don't offer information, especially if it opens up another line of questioning, another line of excuses, whatever it might be. Answer the question as concisely as you can and as narrowly as you can. This is particularly important when you're being cross-examined. If you are being cross-examined by either by the claimant or by representation that the claimant may have acquired, make them ask a question. If their sentence does not end in a question mark, you don't say anything. They must ask you relevant questions. If the question deserves a simple yes or no that's not the way it happened, or whatever, answer it in that way. You want to make, one of the things that you want to do is you want to, make sure that you bring it back to your point of view. Point it back at the claimant if you can at all possible. If they ask you a question that is technically yes or no, but you can qualify it to bring it back around to your point of view, do so. Okay. Again, anything that you answer, you want to try to answer in a manner that points the onus of the question back at the claimant. You do not want to just leave it, try to, if they ask you something that is obviously self-serving, you want to try to qualify that and point it back at them. Make them work for the information. Again, this goes back to what I was saying as far as don't offer more information than what you're asked. Make them work. If they want to play attorney and they want to try to get you to admit to things, then make them ask questions each time that is relevant. It's a lot harder to do this than it looks. This is not television. You're not going to break down suddenly and admit that you did something wrong. Make them ask every single question for every piece of information that they want. So make them work for that. Now, if you cross-examine the claimant, okay, this is an opportunity for you to ask relevant questions of the claimant. And one of the things you'll want to look at, okay, is in the witness statements. I mean, the claimant statements during the adjudication process is a wonderful opportunity to ask cross-examination questions. If during a hearing, and I've been through thousands of unemployment hearings, if I ask 5 questions in a hearing, 4 of them relate to something that the claimant has previously stated in the adjudication process. Because more often than not, the way it works is that the claimant starts off being somewhat honest, and the adjudication they provide with an initial statement that's close to the version of events that you're stating. Then after they're disqualified and they move through the process, there's various statements start to become a little bit more, they diverge a little bit more from the actual truth. This is credibility. You can cross-examine the claimant on their previous statements. So if they've said something that is one version of the events in their initial statement, and now they're testifying about a completely different thing, you can ask them relevant questions about that. There's questions of credibility. You can ask questions about anything you want, about their testimony, about the documents, about relevant information. One thing I want to point out to you about their documents during the course of their testimony. You can object to documents, okay? Objections are oftentimes going to be overruled, okay? Because remember, hearsay evidence is admissible. It's not given weight necessarily, but it is admissible. Even if your objection is overruled, it puts it on the record and it raises in the referee's mind the relevancy of that document. So for example, I'll give you a good example. Yesterday in a hearing that we had, the claimant submitted a bunch of documentation that was 2 years old. We objected to that documentation and the testimony about that documentation as on the basis of its relevancy to the issue. And even though we were overruled, we were on the record and we raised to the referee's attention the fact that this was really not a relevant topic that we were talking about. You can also, oftentimes, since claimants are not particularly professional at this, obviously most people will never go through an unemployment hearing, And if you have, it's probably, this hopefully is your one and only one. But employers tend to be in a position to have gone through this more often than not. So a lot of times claimants hurt themselves by providing information that is actually detrimental to their case. Point that out to the referee. Ask the claimant questions. Why in your documentation did you say X and now you're saying Y and Z during your testimony? So look for discrepancies in the not only in the statements that the claimant gives to the state during the process, but look for discrepancies in their own documentation and look for discrepancies in their testimony. Keep notes during the course of the testimony so you can raise and ask clarifying questions of the claimant. For those of you who've been through an unemployment hearing before, and it's particularly contentious and the claimant is particularly emotional, they tend to be all over the board and they contradict themselves often. Okay. Now, if you don't choose to ask questions, then you can bring these up in rebuttal, and we'll talk a little bit about this at the end. But remember, most importantly, when you're cross-examining a claimant, they're not going to be helpful to you. They're going to probably do everything under their power to avoid answering the question. And if they, in some cases, like I said, the claimant won't even admit to their own name. So don't be surprised if you ask a question and you have to ask it again, and maybe even a third time. By the third time, if the claimant won't answer the question, you've done the damage. Remember, it's credibility. If you're asking simple, relevant questions, asking the claimant to clarify their point of view and they won't answer, that's as good as getting the right answer because it's damaging their credibility. If you do not feel comfortable with asking cross-examination questions, you can cover discrepancies between your testimony and the claimant's testimony in what's called rebuttal testimony. If the referee asks you, do you have any questions, you simply say no, but I would like to offer some rebuttal testimony to the claimant's version. That is not an opportunity for you to rehash your testimony and to provide redundant testimony, but it is your opportunity to cover things that you found in their testimony that are not syncing up to your version of the events. It's a much shorter section of the unemployment hearing. The referee's not going to allow you to go on forever. You want to keep it to as 3, 4, 5 at most points that you want to try to hit. Okay. Obviously, the referee is going to understand that you and the claimant don't agree on everything. You want to emphasize the key elements of the testimony you find most objectionable. Never argue with a claimant. The hearing that I was telling you about yesterday, we were about as far apart in the version of events as you possibly could get. What helped us was that the claimant was making inappropriate comments throughout the entire hearing during our testimony, our witness's testimony. That helps us. Remember, the referee is going to be far more impressed with a dispassionate, factual presentation than they are with all the emotion, and we're not going to try to make any grandiose statements or provide any big Perry Mason moment here. You're going to win more often than not by presenting a factual, very detailed presentation of the events. Everything you do, whether it be documentation, whether it be in your testimony, whether it be in cross-examination, whatever it is, the goal is to chisel away at the credibility of the claimant's positions. You are trying to create doubt in the referee's mind to their version of the events. Again, as I've already stated, it's going to be in documentation, it's going to be in the testimony supporting that documentation, it's going to be in first-hand testimony. Whatever it is that you can do, the goal is to keep chiseling away at that credibility and make sure that your version of the events is the only credible or the more credible position, and the referee has to accept it. Now, one of the advantages of the unemployment hearing process is that you can use representation at the unemployment hearing. Okay? I want to point out to you that in most states, it is not a requirement of the other party to notify you that they have representation. For those of you who are in, say, Missouri, for example, you know, in other states, there's oftentimes you get on the call, not oftentimes, but frequently you get on the call, and the other side has gotten themselves an attorney. There's no obligation for them to notify you of that. Okay. In some states, the referee will notify you, or the actual attorney will send in as a ethical requirement. They'll send you notice of appearance, but there will be times where you can get on the call and not have information that they are being represented. The biggest advantage of having representation at these hearings, whether it be a UIS representative or an attorney that we provide to some of our clients, it provides a buffer between your witnesses and the claimant. There's a psychological element to that, you know, when you show up with representation and the claimant doesn't have any representation, there's immediately a barrier between that claimant and your witnesses. Your witnesses feel more comfortable, the claimant feels intimidated, and frankly, it adds a expertise to the entire event that is only favorable to you. The individual is going to have the training and the expertise to cross-examine. They're going to have the expertise and training to challenge the claimant's position. And again, there is no emotional attachment by the representative to this claimant, whereas you, the witness, have had to deal with this person, you know this person. There is a psychological element to that as well. But most importantly, probably more importantly than anything, is that there's a cost benefit that's favorable to the employer. Our service fees, for example, are $75 to $175. If you use an attorney, it's $175. You know, you use an internal representation, it's between $75 and $100. The average unemployment claim cost $5,500. That's the average cost, right? So to spend $75 to $175 to save $5,500, that's a pretty good return on your investment. So it's not as expensive as you may think it is, and it has much bigger advantages that come along with it than just the cost benefit favorable. It's all favorable to the employer. And if the other side happens to have representation, we would strongly encourage that you have representation, because if the claimant has gone out to get representation, more often than not, and I won't say always, but more often than not, there's a larger problem looming, and this is a free deposition for that attorney. And if you go in unprepared or without representation, you're giving their attorney a free pass. So keep that in mind during the course of preparing for the hearing. Representation is available. I think we have a few questions here, so let me just, that pretty much concludes the our presentation today about this. Obviously, we didn't go into preparing for each individual type of hearing. Your preparation for different types of hearings would be completely different. We wouldn't really have the time to go through all that. So if you have a specific question about preparing for a certain type of hearing, then by all means contact me and I'll walk you through that. UIS representation is requested because in some cases we have it built into the service fee, and another times it's a la carte. So all you have to do is you let our representative know, your claims manager know that you are interested, or during the process of preparing them, you let us know, and we can provide you with that, provide you with representation. In some states, you must be a licensed attorney in the state. Most states, you do not have to be. Most states, UIS representative can participate and represent you as your legal agent. Do you have examples of cases you discussed during? Yes, we could talk about that. We have all kinds of case studies and discussions. During the next couple of seminars, we're also going to be talking about how to handle different types of issues. The next one, for example, the next webinar we're going to talk about is how you handle protesting and dealing with attendance-based unemployment claims. So some of that might be discussed during the course of the next few webinars, but if you have any questions regarding actual cases, or you have more specific questions about how the hearing process works, then by all means send me an email or contact me, and I'll be happy to talk to you about it. Are there, let's see. That's a great question, John. Most hearings that are telephonic, yes, you can have representation on the telephone hearings, and the hearing representative does not have to be in the same does not have to be at the same location as you. Probably 99% of the hearings that we do now are telephone. We participate in hearings all throughout the United States, and pretty much we've done one in just about every state that you can imagine. So yes, you can have representation on those as well if you want. The claimant statements, when we talk about those are wonderful pieces of information. I strongly encourage you to read through those whenever you possibly can, because those are a valuable insight to what the claimant is thinking. And like I said, more often than not, desperation sets in, especially if the claimant has been disqualified. And if you compare the statement they initially gave the state when they filed their claim and the statement that they send in with their appeal, you get a lot of discrepancy in there. And it's just a matter then of really asking a simple question. You say, hey, Mr. Claimant, on such and such date you told the state this, and now you're saying this. Which is true? And you know you're not going to get a straight answer. You know you're not going to get an answer that is really all that helpful to you from a tangible evidentiary point of view, but it does damage their credibility because it's pointing out to the referee a clear deviation in their story. And it's making the referee think which version of the events is true. So that's probably the biggest advantage you have in talking about those claimant statements. The next the attendance related webinar is going to be at the end of September, probably the last week in September. We just haven't quite got that scheduled yet, but we'll be just discussing how to document and to handle attendance related issues and how you can make that documentation a little bit more effective towards handling separations dealing with attendance. All right, well, if there's any other questions, we'll give a minute to see if there's anybody else who needs to type anything. If not, appreciate you participating. We really enjoy giving you this information. It will be loaded up on the website, and you'll get a copy of it, this webinar, through the email. Also, if you have any questions, do not hesitate to give me a call or email me with specific questions, and I will be happy to answer those for you. So again, thank you very much, and we look forward to talking to you again next month.